Good morning, or good afternoon, rather, everybody. My name is Chris Justice, and I'm an employment lawyer with Samfiru Tumarkin. And I'm here today, as always, to hopefully answer as many questions as I can within the time permitted. So, all questions to do with employment related matters. Maybe you've been let go, you're wondering if you've gotten a fair severance package. Perhaps you've just joined a company and you've got some questions on your way in, or maybe something's happened in the middle of the work relationship, whether it's years in, weeks in, months in, whatever it ends up being. Do get your questions in today. And as I say, I'll answer as many as I can. As I typically do, I like to start off every session with some topics or some news that's coming around. In this particular case, I wanted to start by addressing some issues related to warm or hot working conditions. As many know, with the summer coming, the temperatures are definitely rising, and this can mean a very uncomfortable work environment depending on the type of job you have. So maybe it's a job that requires you to work outside, do some heavy lifting, or maybe you're inside an office or in an area maybe with little cooling and the temperatures are very high indoors. And so then you could be in a situation where the temperature of the working environment, inside or out, just rises to a level that is unsafe and that causes you concern, concern for heat stroke, overheating, whatever it ends up being, but a concern nonetheless. And so I wanted to quickly touch on this, just given it's topical, and to sort of let people know what their rights and their options are. So to begin with, in terms of temperature itself, there's no set amount of temperature or set degree Celsius that the law says is unsafe or unworkable or illegal. It usually comes down to a case-by-case basis. But having said that, while there may not be a definitive sort of threshold in terms of the temperature rising past a certain degree, employers are still nonetheless obligated to maintain a healthy and safe work environment. And included in that obligation, or implied within that obligation, are safety concerns relating to heat. So usually if you're in a situation where the indoor or the outdoor environment is in the high 20s or above 30 degrees Celsius, I find in my experience that's when a lot of people may have issues in terms of their ability to do the work. And so I think it's appropriate, if you're in a situation like that, to address the situation with your employer, with your manager, with your boss. Let them know that the temperatures, whether it's in or outdoors, has risen to a level that is causing you issues, or affecting your ability to do the job. Or you may, again, just be concerned with potentially getting heat stroke, or suffering to some degree with prolonged work in this type of environment. And as I say, your employer has to try its best to accommodate those concerns. So whether it be allowing for more frequent breaks during the day to let you rest, take a break, whether it be to ensure that there's an adequate supply of water, or that people have access to hydration. Maybe it's a matter also of accommodating the shift or the working situation where you're maybe only working certain hours that are not as hot, or perhaps engaging in more strenuous activity or heavy lifting in sort of a more shaded area, or again during a time of the day where it's not as hot, or a time of the week where it's not as hot. But there should be this accommodation given by your employer due to this obligation they have. Now, if you raise your concerns with your employer and you let them know of the issue or what you're experiencing, and you let them know maybe some possible accommodation requests, as I've mentioned before, and there's pushback, and the employer just does not want to adhere to its obligations, does not want to listen to what your concerns are and your accommodation requests, then at that point, your employer may likely be seen as failing in its obligation, or in their obligation to provide and maintain this healthy, safe work environment. And that could be a huge issue, because the Ministry of Labor could get called after that, whether it's from the employee themselves or somebody else, to do an investigation. And if the Ministry of Labor determines that there is an unhealthy or an unsafe work environment, that employer could be subject to possible fines or suspension to some extent of their practice. So it can get employers in a bit of hot water when they refuse to accommodate their employees in this sense, and once the Ministry of Labor steps in. Or alternatively, in lieu of the Ministry of Labor, someone could also contact an employment lawyer like myself, relay the concerns, sort of set out what the issues are, maybe what back and forth there's been in terms of the concerns brought forward, the accommodation request made, and sort of what the employer's response was. And that employment lawyer may also be able to assist you as far as letting you know, as I said from the beginning, what your rights and what your options are. No one has to be forced to work in an environment that's unsafe for whatever reason. And if the employer ultimately doesn't want to rectify or fix the issue in light of these concerns, then that can lead to what's known as a constructive dismissal. That being where there's a significant breach of the terms of someone's contract. And as I say, there's very few very important terms of someone's employment contract, but one of the most important terms is the implication that the environment is still going to be safe, healthy, and free of these issues. So that's what can lead to a violation of that obligation and therefore the constructive dismissal. And then you as an employee may actually be able to exit the situation, leave the company, almost as though you're resigning, but it's a very specific type of resignation. You're basically being pushed out on account of not being able to work in that environment and on account of the employer not doing what it needs to do. So then there's that scenario where you could potentially exit the situation and go after your employer for your full severance, not to mention possible other damages relating to the breach of their obligation to maintain a healthy and safe workspace. So again, whether it's from the Ministry of Labor coming in to look into the situation to investigate, or it's an employee asserting their right to severance after they've been constructively dismissed, and then potential additional damages on top of that. As I say, there's a lot for employers to think about, and all the more reason why they should and need to be accommodating these types of issues. So if you're in a situation like that, maybe you've raised it, there's not really much happening, and you're seriously concerned about your own health and well-being or that of other workers in the area or in the facility or outdoors, I'd say definitely give us a call at the very least. We can let you know what your options are, what the best course of action would be, whether it's to go the Ministry of Labor route, whether it's to maybe have another discussion with your employer to see if they're willing to do something, or whether it's just to have the lawyer themselves step into the picture to try to get the situation addressed. And if not, at least ensure that you're getting your full severance for your employer's failure to adhere to their obligations. So that was sort of one talking point I wanted to raise, again, just because we've got the rising temperature levels. And I know in June, July, August, it's going to be very, very hot for a lot of people out there, depending on their job. And so those people just need to know that they do have options and that their employer should be doing something in those scenarios. Just before I get into some of the questions, another thing that was going around in the news, which I've mentioned on the show before, has to do with layoffs. There's a lot of layoffs, a lot of terminations that are occurring across various different industries. The story that I saw most recently had to do with Lululemon letting go, or at least preparing to let go, a number of their corporate positions, whether it be in a mass layoff situation or on an individual sort of one-off basis. But whether you're someone maybe at Lululemon who's being impacted by these layoffs, or you're just someone who has recently lost their job due to a layoff, or maybe something due to the issue with the tariffs south of the border, do know as well that you are entitled to your full severance, that you should not be signing off on any severance package, no matter how good it may look or seem, and definitely to get in touch with our law firm to ensure that you are getting a fair package. 8 or 9 times out of 10, in my experience, I find that anyone who's let go, whether it be due to tariffs or restructuring or financial issues, are being let go and offered a package that is, I'll say, woefully inadequate, very, very much lower than what the actual person's full severance rights are. And again, all the more reason before you sign off on any severance package, before you sign any release that would prevent you from going after the company afterwards, definitely do give us a call so we can ensure that at least the package is fair and reasonable. And if not, we've got a lot of experience on our end negotiating packages like that, whether it be without a lawsuit being required at all, or potentially getting into litigation and to legal action if that becomes a necessary evil. Now, with that said, I've got a couple more topics I wanted to touch on, but I'm just going to answer some of the questions first. I see some coming in. Got one in from Jacobo on YouTube who's saying, I would like to know if your office see WCB cases. Thank you. So I think by WCB, you mean Workers' Compensation Board. So we don't necessarily specialize in workers' comp board cases, but we do have a lot of information and knowledge on how those cases tend to evolve, and as well the types of things you need to be looking at or focusing on to maximize your case. So with respect to your question, I would say definitely give us a shout at the very least. We can set up a consultation with you. We can discuss your case, whether it has to do with workers' comp, or there might be other issues that you haven't even thought about that could be of value, that could give you more leverage. And again, at the very least, we can let you know sort of what your options are, what paths you can take, and what might be the best path to take. So for anyone in that person's situation or themselves, give us a shout and we can definitely set something up. I've got another question in from Break It Like on YouTube who's saying that they're a longtime employee. They've been in management for the last few years. They've never had an employment contract, and they're asking whether they should advocate for one. Employer is taking layoffs over work shortages. So with respect to your question about whether you should advocate for an employment contract, typically I would say no to that. I understand, or I acknowledge that there are some good things that could come with a contract of some sort. For example, in a contract, you're often going to have your position. You're going to have a list of the duties and responsibilities required in your position. I don't think you need a contract for this, maybe a job description or a job duty list. And the reason why I think it's important is because you want to have something that's sort of in black and white, setting out very clearly what's expected of you and what your job actually entails. Because when you don't have a job description, oftentimes what I see happen is somebody will be doing their job, excuse me, and over time, that job will morph, it'll evolve, things will change, things might be added to someone's plate, things might be taken off someone's plate, but it just happens over a period of months or years. And then it becomes hard to track what these changes are. And eventually it gets to a point where by year 3, 4, 5, 6, the job is very much different than what initially was the case when you signed up for it. But then it becomes hard to figure out what changes were made along the way, what was expected of you, what wasn't, if there's no job description or job duty list there. And so I think for that reason, a job description can be very helpful so that you can always sort of compare that or look back to that anytime there are changes made and determine whether or not that's something that's within the scope of your job. Because if not, then you may have the ability to kind of take a stand to push back and sort of say, well, no, I signed up to do this. It says I have to do A, B, C, D, E, F, G. Now you're telling me to do, F, H, I, J, right? Or I'm doing A, B, C, D, E, F, G, and now you're taking away A, B, and D. And so that can be easier to track these changes and just sort of assess, whether there is a breach of your employment. So I'd say a job description is important, but you don't need a contract to get that. The reason why I don't typically advise people to sign contracts is because for the most part, the contract is in the company's favor. There's not going to be a whole lot in a contract that's going to benefit you, other than, as I say, maybe having clarity over what your job entails. Another benefit to an employee as far as a contract is concerned could also involve some clarification over how they're paid. So a lot of cases, you're going to be paid an hourly wage, you're going to get a base wage. There's not normally a dispute over that, but there does come to be a dispute over things like commissions, bonuses, other sort of items that are compensation related. And a lot of times that's never formalized. And so again, months pass, years pass. Someone comes to me saying that they believe that they're owed a bonus or a big commission payment. But then when we look back at the situation, maybe look to see if there's a bonus plan or a commission structure in place, there isn't something written down. And then just like with the job description issue, it can be problematic when trying to figure out what you're owed if nothing's really been formalized in that sense. Whereas if you do have a clear bonus plan or a clear commission plan, at least that's going to give you a better idea of what you need to do in order to meet the threshold for the plan, to get the bonus, to get the commission, what the metrics are, what the companies are sort of looking at in terms of determining how much bonus do we give someone versus another person. But I also think that a bonus plan or a commission plan could be given and could be formalized without having a full-blown contract. So I think if you can get something like that clarified outside of having to sign a full-blown contract, as well as your job description, setting out what your duties are, that's going to cover a lot of bases. Because otherwise, when I look at contracts, I just see a lot of information in there that benefits the employer. So there's a lot of times a termination clause, which will limit someone's severance rights. That's one of the biggest issues with employment contracts is, it'll say what your job is, how much you're making, etc. But then pages down, it'll have something about termination. In the event that we terminate your employment without cause, this is what we're going to give you. And people might look at that and think it's all well and good. But the fact is that these types of clauses, these termination clauses, are almost always trying to limit your rights to the very bare minimum. And if you're an employee at a company for 2 decades and you've got a contract that has a termination clause like that in there that's really good and well worded, you may only be able to get 2 months of severance for 2 decades of employment. But if you don't have a contract, you don't have a termination clause, and then it's just silent on that piece, and you've been with a company for 2 decades and you're then let go, you could be looking at potentially 2 years of severance. So the termination clause or the termination provisions in these contracts is one of the main reasons why I'd almost avoid having a contract. If you're going to have a contract, it's better almost to have it just on one page. I get really concerned when I see these 10, 15, 20 page long contracts, because again, I know that 95% of what's in there is to the employer's benefit. So I generally tend to steer clear of that, although I do know a lot of companies insist on contracts. That's where some of the issues come about. But if they're not going to give you a contract and you've been in management for a few years and they should, if they ever let you go, it's going to be better you not having a contract than having one. But having said that, if there's something specific to your case that you're looking for protection on, there could potentially be benefits to putting it in writing, but that may not mean a contract per se. So I'll break it I'd say without having a bit more information, it's hard for me to say 100% whether it'd be in your benefit, but my guess is probably not. That said, if you do want to give us a shout, we can set up a consultation as well with you and kind of talk through what your concerns are, or what you're looking for, because as I say, you may be able to achieve what you're after without having a full-blown contract and without kind of tipping off the employer that maybe they should have something formally in writing for you, which, as I say, can pose some problems down the line. Got another question in from Alex on Reddit, who's saying that their company has recently adjusted their security and now they're required to use their cell phones. Can our employer force us to use our personal device, or do we have the right to refuse and request an alternate way to handle workplace security? I definitely think in general, you do have the right to request an alternate way to carry about your job. It may also depend on what document or contract you may have signed. Sometimes people sign contracts that mention, using their phone. So it could be a term of your employment. But outside of that, and I guess as long as you haven't been using your own cell phone for, months or years on end already, because that might give the employer the expectation that this thing will continue. If it's sort of a recent adjustment, then I can understand the hesitance to use your own cell phone. Giving out your phone number, your private number to clients or customers definitely can be problematic. And so I think the employer generally should be looking to try to accommodate that. I don't know if you've tried asking for some accommodation or to be provided with a work cell phone or some other device, but that's probably where I would start, see what the employer says in response to that, and maybe take it from there. But thank you for your question. I've got another question in from In the Berg on YouTube who's saying their employer is saying that their accommodation request goes against their policies. It would really just require me to change my break times, split them up more, and make some adjustments to my setup. Is there a threshold for allowable accommodations? Like if I need $200 of ergo equipment, is that too much? So there isn't a specific dollar amount or threshold in terms of how much is too much. It kind of depends a little bit on case by case. So for example, if I work for Walmart, very big company, and I have some back issues, and I've got a note from my doctor that says this employee requires ergonomic equipment, like a chair or a desk or something, for a cost of $200. And I ask my employer if they can accommodate me by providing this, and they say, no, $200 is too much. Well, if you're coming at that from a perspective of Walmart, that's not going to be looked at too favorably. If you're working for, let's say, a small mom and pop shop, maybe there's only 3 employees, and the company is in financial dire straits, there could be a scenario where it may be too much. But the thing that you should remember is that, and employers for that matter should remember, is that just because an accommodation burdens you or inconveniences you in some way doesn't mean that that's a reason, I should say, to not accommodate the person. Accommodations are expected along the way, and some inconvenience is expected for those accommodations. Right? There's a big difference between having a $200 ergonomic setup versus asking your employer to retrofit the entire workspace to include this, that, and the other that would cost tens of thousands of dollars. And so when employers say, no, I don't want to do that, or this goes against our policy, that raises alarm bells for me, because I'm curious to know what that policy is. So it may be helpful if you contact our office after today to set up a consult, to definitely provide these policies, and just to give us a better understanding of what their pushback is. Normally, that type of equipment should not be too much of an accommodation. When it comes to changing break times, splitting them up, again, sort of depends on what's exactly being requested. But depending on the request, again, even if it's somewhat of an inconvenience, employers are expected to make these changes. So if I work 9 to 5, Monday to Friday, and I have a break at 12 or 12 o'clock and 2 o'clock, and I want to change the break time to 11 and 3, or maybe do smaller breaks, maybe one at 10, 12, and 2, assuming the time's relatively the same overall. Again, I don't think that's too unreasonable of a request. And also, if you've got the medical backup or support from your doctor, I think that goes a long way. When it comes to accommodations, it's always helpful to have a note or something from your doctor that supports your request, especially if it's something related to a health condition or issues physically or psychologically. If you've got a doctor's note, you're asking for accommodation, it doesn't change things too drastically or cost the company too much, then the employer should be accommodating them. If they don't, then they could be seen as having failed in their obligation to accommodate, which could open up a big can of worms for them as far as having to pay you severance, having to pay damages for failing to accommodate. But yeah, unfortunately, it does happen far too often where employers just push back and say, no, we're not going to do it, which then may need for there to be a lawyer getting involved to jump into the picture to try to sort that out. But in the Berg, the stuff you're mentioning to me on the face of it does not seem unreasonable. It doesn't seem like a massive request. And if you've got the medical backup and support from your treatment provider, I think that employer is going to be hard pressed. I've got another question in from Brinana on YouTube who's saying that a coworker blamed them for a bunch of problems at work and made up some lies. My employer let me go because of it, and I want to file a wrongful dismissal suit over this. It doesn't seem right. And then there's a follow-up comment about thinking employers should have to provide phones or pay for part of your bill if they want to use your phone for a work function. That part I agree. So a lot of times where employers require you to use your phone, say your personal phone, you're incurring costs by using that phone, whether it's long distance charges or whatnot. Typically, there should be an expense sheet or an expense form you can fill out to submit your expenses to that employer. This may be detailed in the employer's policy as well. But again, on the face of that particular issue, that doesn't seem unreasonable whatsoever. Now, with respect to the first thing you brought up, though, so you're let go because of being blamed for problems and having some lies told about you. So I guess it depends on what's being said and why it is that the employer let you go because of it. I'd like to think that employers would look into these things, investigate these things, and make sure that there's validity to these things. Sometimes employers say they do investigations, but they don't. And it's found out later on that it was a faulty investigation. It wasn't thorough. Maybe it was bias. And as a result of the findings of that investigation, someone gets let go. But if it's faulty or there's some issue with the way in which the employer carried things out, that could be a wrongful dismissal 100%. Not just that, but anytime you're let go, even if the employer believes something that someone said about you that's not true, and they let you go, then you're still likely going to be owed severance. That would be a wrongful dismissal if they've let you go and not provided you or paid you anything. So the question also becomes, did they give you anything on your way out? So if you've been let go, whether it's because of something someone else told them or because they just don't like the color of your shirt, both of those things may be perfectly legal, but what may be a particular problem is not being given any severance or compensation on your way out. So that's number one. And then the second thing, as I mentioned, just has to do with the bad faith angle. So again, what due diligence did the company do? Is there an element of bad faith here? Is there an issue of a faulty investigation? Because that could open up a bigger can of worms as far as punitive damages being owed or additional damages being owed on top of the severance that most often people are going to be looking at, regardless when they're let go. Even when employers say that they have cause to let you go and that this is why they're not giving you any severance, 9 times out of 10, the cause is not there. You're still owed your severance. So give us a shout 100%. It seems like there's some issues going on and definitely want to make sure that you get what's owed and deserving your way. I've got one more question just before I end things from New Name on YouTube, who's saying, if an employer is ordered to pay loss of wages after a reprisal termination, would that cut into or completely diminish your severance owed under common law? And yes, it could. So if you are let go, let's say as a form of retaliation for bringing forward a complaint or alleging harassment or bringing a human rights concern, and then in reprisal, retaliation to that, you're fired. You're looking at your severance typically. So depending on how long you've been at the company, for most people anyways, maximum would be 2 years of severance. So if there's an order to pay severance, so let's say I'm let go June 1st and the employer is ordered to pay my wages from June 1st to the end of this year. And then let's say later on, I'm deemed to be owed severance of a year. So from June to June, typically the money that was paid from June 1st to the end of the year, that would be in partial satisfaction of severance. So it may not completely diminish the severance you're owed, depending on how big of an order it was to pay those wages. But if the wages are being paid as severance specifically, in other words, post-termination, and they're not being paid as damages or something other than that, then the likelihood is that it would cut into the severance you'd be owed under common law. But I just don't want you thinking that that means you don't have a case or that there's not going to be enough left over to make it worthwhile. So I definitely as well, New Name, give us a shout. We can get some more information, some more details from you, and just tell you one way or another what you're looking at, what the value of the case might be after these wages are paid or after this order is complete, and then definitely go from there. But again, that does it for my time today, everyone. I thank you very much for attending. Hopefully you enjoyed today's session. We do have these going on all the time, as many of you know. So if I didn't get around to answering your questions today, we've got another Q&A you see down below there this Thursday with Alex, who is more than capable of answering any questions, all things employment law related. But until then, everyone do take care. Thanks again and enjoy the rest of your day. Bye for now.